You're listening to Explain That by Velocity Legal, the podcast that keeps business owners and professional advisors ahead of the curve in an ever-changing legal landscape.
When a company fails to comply with its tax obligations, the tax office can issue a director penalty notice, making the directors of a company personally liable for the debts of a company. There are very strict timing obligations regarding these, and if they're not met, the tax office can take action personally against a director of a company. I'm joined in this episode by Director Seamus Ryan and Senior Associate Sascha Kenny. Welcome to the show, guys.
Thank you very much, Andrew.
Thanks for having us.
Now, I'm really excited to get into this with both of you because I understand you've both got a lot of experience in dealing with a director comes to your door, metaphorically, of course, it's on email, but comes forward and says, I've got this director penalty notice, what do I do? And I understand you've both got a lot of experience dealing with that situation, both from a technical and an emotive perspective as well.
That's right, Andrew. So director penalty notices are not something we had to deal with during the COVID years. There was effectively a pause on them. During the COVID years, the laws were updated so that instead of just being PAYG or pay-as-you-go withholding and superannuation, it was expanded to include GST. But because of the pause, I think that that's something that was kind of lost in the ether for a while. And then as recently as 2022, they started the enforcement process, and all of a sudden we were confronted with an influx of them. We've had quite a lot of them lately. And because of the very tight timeframes that are imposed on directors to take action under them, it's one of these matters where when a director receives one, action has to be taken almost immediately. And so it's something that's occupied us quite a lot.
Yeah, and I guess over the COVID years, as disputes, lawyers dealing with director penalty notices, I imagine it was probably a pretty quiet time for that sort of insolvency type work, or ATO bringing debt recovery action.
That's right. We didn't typically see the ATO issuing them or taking enforcement action in respect to them during the COVID years. And I think the result of the ATO ramping this up so significantly in 2022 and onwards has been that it's caused a lot of emotional and financial distress for directors who may have thought these liabilities were in the past and suddenly were hit with these notices that required these directors to take action within a limited amount of time, but also required them to review books and records for matters that were obviously years old. And in many cases, those books and records ceased to exist or are located somewhere else. And so it does cause a lot of emotional and financial pressure on these individuals, and something that our firm has seen a lot of in the last 12 months.
Yeah, that's a good point. And also there's sort of, I guess, people who maybe they started a business in 2019 and then, the sort of the landscape was the ATO was sort of a bit of a soft creditor, I guess. But that was a very, unique time. And now we're sort of, I guess, back to normal, or perhaps maybe a bit beyond that. And the ATO has sort of made it very clear that they are not a bank. They want their money.
Yeah, well, that's right. And I think you had multiple scenarios. In some cases, you might well have had a very profitable business before COVID that became less profitable during COVID. But I think in some cases, you might have had a business that was getting close to hitting the wall. But because of the ceasing of enforcement action by the ATO during the COVID years, they may well have traded on the assumption they could keep going, maybe a little bit of denial about the true state of the business. And so they've traded through for a few years, and then all of a sudden there's enforcement action being taken in respect of debts that they weren't anticipating being collected, and they're faced with sudden decisions. And we'll get into when you need to make a decision and what the consequences of that are shortly.
Of course, the other sort of, the trend that's happened over the last 12 so months is really sort of this cost of living crunch and, a tightening of economic outlook, I guess, and that's probably had a trend to play or a role to play in this discussion about DPNs, about whether a business is viable or not.
Yeah, well, exactly. I mean, you had rising interest rates and, as you say, a general cost of living crunch, and so when people have expenses that are already increasing, perhaps their own debtors that are not recoverable or not paying in the short term, and then you get hit with a DPN and you're required to take action in relation to it urgently, that puts extreme pressure on.
Yeah. So there's that trend around the change of economic circumstances, the change, the COVID bubble, we'll call it. But then that other point you mentioned, Seamus, around changes in the actual law regarding DPNs. Could you just go back to that point? Essentially, was it the GST was brought in, which was a bit of a, would you call it a game changer?
Yeah, well, it was. I mean, it's quite clear what the intent of the DPNs are, which is that for taxes that you're meant to be collecting on behalf of the government, it reinforces that you are collecting them on behalf of the government. They're not meant to be pooled with, say, your general income. You're meant to be holding it aside, and so it's a liability, and it's a personal liability if certain preconditions are not met. And so adding GST to it is perfectly logical. PAYG, superannuation and GST are not amounts that are meant to be held by the company. They're amounts that are meant to be paid by the company on behalf of others. So it was a logical extension of it, but at the same time, I think that it's something that was just overlooked because of the timing. Yeah,
because it was in early 2020, wasn't it? And, we all had bigger things on our mind at the time. But that point, I get that point, essentially, that the whole point of these director penalty notice rules is that, hey, a company's it's got obligations to pay the PAYG, pay the super, and also, well, GST kind of works the same as those things too. So essentially, it's yes, the company can use the money, but if it doesn't pay it, there's pretty severe consequences.
Yeah, and when the legislation was first introduced for DPNs in 1993, one of the key reasons was to counteract what was seen to be phoenixing activity by companies who would rack up these debts to the ATO and then put the company into administration or liquidation and effectively start another company trading in the same industry using the same plant and equipment. By making the directors personally liable, it's a pretty strong disincentive for that kind of behaviour, because you might 2 years later think that you've sort of beaten the tax man, as it were, only to find that you've now got a much more serious problem, which is that you can be sued by the ATO in your personal name and bankrupted on that basis.
Yeah.
So I think adding GST was a natural addition to the current regime.
So it's a pretty significant weakening of that corporate veil, that separate legal person notion, where if a company's got these amounts that the directors can be personally liable for. I want to take you to a situation. Let's say I'm a director of a company. The company's got some PAYG, GST obligations. What happens? What's the first step? Is it the notice comes out, practically, and then the director says, "What's this? What do I do?"
So it all started in about 2022 when 50,000 warning letters got sent out to directors regarding amounts that might be the subject of a director penalty notice. So I think for a lot of the directors with whom we've spoken about director penalty notices, there was some forewarning. But of course, as the way these things often go when you have mass mail out type communications, a lot of it has not gotten through. So it might well be that the first a director hears of it is when they receive the director penalty notice. With respect to what they can do about it, we have the concept of lockdown DPNs versus non-lockdown DPNs, and where lodgements occur within 3 months of the due date, those amounts can be non-lockdown amounts, meaning if action is taken, and we'll talk about what that action is in a moment, then that personal liability can be avoided. But if they're lockdown amounts, as in lodgements are over that 3 month period, then no action you take short of paying the debt gets you clear of your personal liability.
That makes sense. I guess, when we talk about COVID years and we mentioned the word lockdown, I think my mind goes elsewhere. But what you're really saying is if a company hasn't lodged on time or close to on time, there's no way out of the liability.
Unfortunately, lockdown in a DPN context is no less serious than in the in the civil society context. Unfortunately, also is that the DPNs do not readily disclose in a clear way to the recipient whether an amount is a lockdown or non-lockdown amount. So we have these recipients will receive typically a DPN that will state the bracket of tax for which it's collecting or which it's alleging that a debt is owed. And then there'll be a series of columns with different amounts and then some dot points following those amounts indicating the options that the recipient has to take after that. The problem is that for the layperson, the director that may not understand the Taxation Administration Act.
It's probably the first time they've seen a DPN as well.
That's right.
Yeah.
It's not at all clear which amounts are able to be remitted back to the company if action is taken and which amounts need to be paid within that 21-day period. So I think, that's from a lot of the confusion we've seen from the people that come to our firm is based on what steps are they actually to take, what's the best thing they can do at that point in time. And often, unfortunately, they've come in and it's already past that 21-day period and their options have become
even less
truncated.
Yeah. Well, it's a good point you make. If it's not really that clear which one's a lockdown, which one's a non-lockdown, then as a director, I'm saying, I've got to do something within 21 days. Well, what's the cost benefit analysis? It's kind of hard to do that. I mean, 21 days isn't long anyway, but it becomes even harder in that situation.
Yeah, so often when you receive them, and this is what Sascha's talking about, you'll have these columns and it will say the amounts that were lodged within the three, where lodgements were within time, and amounts where they were not. But to a layperson reading that seems like meaningless information, and very often when we talk to directors, they haven't grasped that that's what the difference is. Yeah. There's not necessarily a total. And so with respect to non-lockdown amounts, if you are to appoint an insolvency practitioner, but by that I mean a liquidator, voluntary administrator, or you commence a small business restructure, then those amounts can be remitted. And if you don't do that, then they remain owing. With respect to lockdown amounts, it doesn't matter what you do, but it might well be, and this is something we see very commonly, there might be, say, $100,000 worth of non-lockdown amounts and $80,000 worth of lockdown amounts. So you can save yourself $100,000 by taking action really quickly, but you may not know that just by reading the notice. Yeah. And from a standing start, you receive the notice, assuming you receive it on day one, which a lot of people don't. 3 weeks is not very long to get yourself in order, seek advice, find out whether any of those options are applicable to your business. Of course, you may have to make a decision as to whether the business is viable. It might be that you could trade through it and pay out the amounts, or it might be that there's no real hope and it's best to appoint. But based on the quality of the notices or the quality of the information on the notices, a lot of people who have come to us have been quite confused about how much they can save by taking those steps, and then they've got to work out whether they want to take those steps even confronted with that information.
Yeah, it's a lot to process and take in and make a decision about in 21 days. If we're talking about a business, you're essentially working out if it's viable or not, because if you don't take those actions within the 21 days, then that's essentially it. And one question I wanted to ask is about payment arrangements, because I understand anecdotally you can still talk to the ATO and agree to a payment arrangement, but that doesn't change the fact that a DPN's been issued and the consequences of it, does it?
That's right. And there's a variety of mechanisms available to negotiate payment arrangements with the ATO following the issuing of a DPN. And some of those options are sort of set out on the form. Some of those options are not, and are probably best handled by a legal practitioner. But I guess the key point to know is that once that 21 days has expired after the DPN was first issued, the ATO can then rely on that DPN in terms of commencing any proceedings against you. So a lot of people come to us are kind of quite concerned that they owe this money. When do they need to pay it? The answer is not always immediately clear. We might not say immediately, but we might say the ATO now has the building block in place to commence an action against you. So it is a good time to commence that negotiation period with the ATO, because once they start proceedings, there's less options available.
It's kind of like you're playing a game of cards and the other player's got, the boss card or the draw 4 in Uno, and, they might not play it straight away, but once their DPN's issued, that they can do that at any time, and they've got that right.
It's an invidious place to be, to have a DPN issued against you.
Yeah, and you in your practices, you've seen actual situations with DPNs issued years ago and enforcement action happening many years later, haven't you?
Yeah. This relies largely on anecdote, but what we've seen as they have rolled into our office is that there seems to be a chronological order to the enforcement, as in we're seeing quite a lot of DPNs that related to debts from, say, 2016, 2017, and slowly but surely we're getting more and more in later years. You're quite right that very often a DPN was issued quite some time ago. Everybody's sort of forgotten about it, or perhaps didn't receive it, didn't pay it any mind at the time, and then they receive a writ against them personally. It's not at all uncommon that, for example, the company in respect of which a DPN has been served has gone into some form of external administration years ago, meaning they don't have access to the books and records anymore. And so that is a quandary that a lot of these directors are finding themselves in.
And because those DPNs, those director penalty notices, can essentially be issued based on, the commissioner's estimates of what the company's PAYG should have been, which might have been different to what's actually been lodged.
Yeah, so we've certainly seen that where an estimate has been made well after the fact, and that might, for example, have been triggered by an audit or something like that. And so the director receives a DPN in respect of a company that's long gone, and in respect of which it might be that the company superficially paid all of the amounts that were owing at the time. But if they've, for example, been grouped with employees from another entity or something like that by the ATO, then they receive a DPN with respect to PAYG years later. And their ability to defend themselves is obviously limited if they don't have the books and records of the company anymore or years have passed.
In respect to DPNs issued in 2016, we're talking about 9 years ago. Increasingly, you'll see that practitioners, accountants, financial advisors and so forth that you might need to speak to in order to get your affairs in order no longer work in that industry, retired. It becomes very difficult to challenge an estimate that was in respect to affairs 9 years ago when you don't have the people that were working for you at the time at your disposal.
Yeah, that's the I'm trying to think of the words for it, but that's the thing that happens with time, that the longer something goes on, the harder it is for anyone to remember or produce documents. And that's why we have things like statute of limitations and why the commissioner usually has a 2 or 4 year period to review affairs. But with these DPNs, that's not the case, is it?
No, that's right. They have no fixed time to pursue them. And one other thing is that there are defences available with respect to a DPN. We can cover those in a bit more depth later, but crudely they are illness, or you took all reasonable steps to comply with it, even if you weren't successful. It's as much a problem with respect to trying to raise those defences where time has passed as it is for trying to assess whether the DPN is correct. Because if, for example, you want to try to demonstrate that you were ill and weren't able to manage the affairs of the company, but 9 years have passed, the likelihood of you having all the records that might help you respond to the DPN or defend yourself are probably slim. Your recollection of events may not be as good. We've had instances where, for example, a key advisor has died in the 9 years that have passed, meaning your ability to get the information you need to respond to it is not there. So I suppose in terms of what directors can do when they're confronted with that sort of thing, I mean, obviously having great records is a major bonus, and maintaining consistency with advisors is a massive bonus too. Getting your lodgements up to date in the first place and
don't lodge late. Yeah,
don't lodge late and pay your taxes on time. Those are all steps that can be taken proactively. But when you get to the point where the DPN has been issued or enforcement proceedings have been taken, you can find yourself at a real disadvantage where a lot of time has passed.
I wanted to ask you a question about sort of co-ownership type situations. Let's say I've never been a director before. I'm coming into an existing business, or maybe I'm in the business already now and I've got concerns. What can I do as a director? What sort of practical steps can I take to avoid, personal liability myself?
Well, the critical thing is look at the books before you become a director. Have a good look at them. So if you're talking about purchasing or buying into a company and going on as a director, having your financial and legal advisors look over what's there and making sure you get proper access, perhaps to the ATO portal, to make sure that there isn't, for example, a debt that already exists in respect of which a DPN could be issued, because you may find yourself with a personal liability for it down the track. These are all critical things, but these are very real problems. We see also the issue where you have multiple family members and fluctuating directorships. The wife gets put on for a period, a son comes into the business, everybody trusts everybody, everyone assumes that everyone's been doing the right thing and the business is well run. And then they find that it hasn't been, and they've got a personal liability.
Yeah, and the more directors, the more that's spread around.
Well, it's not those directors are joint and severally liable as well for those DPN amounts. So it's not a case where, say, there's 3 directors, they receive 33% each of the underlying debt. They'll each receive a DPN for the entire debt, and how they choose to navigate that DPN from there is a matter for them. Once the DPN has been served and that 21 days has expired, they will each be liable, depending on how the ATO takes action from there. Now, they might raise, if say, another director had paid that debt, that might come in as a defence at a later time, but it still doesn't solve the problem of the liability they owe at that point in time.
Yeah, everyone's on the hook, and if the other director has, left the country and has no assets, then it doesn't really help you.
The ATO might choose to go for the director that still is in the country and still does have assets, and I think that's the problem.
Yeah, and critically, you can't extract blood from a stone. So if there are 2 of you, but you're the one with the deep pockets, and your fellow director has no assets, maybe no assets at all, or no assets in his name, then if he
go for the path of least resistance.
Exactly, or they may choose to go bankrupt. And if you're the only one that's left as a viable candidate, then it may well be you that ends up coughing up the entire amount.
You end up holding the bag, so to speak. Yeah. So, Seamus and Sascha, we've talked about sort of proactive steps, but let's just say we're in that unenviable situation where we're a director and one of these DPNs turns up on our doorsteps. What are the practical steps or questions that should be running through that director's mind?
Well, first things first, they should immediately contact their accountant, or if they've got access to the ATO portal themselves, and try to make sure that what's said in the notice is correct, because we have seen errors. Assuming that it is correct, the next step is to work out whether there are lockdown amounts and non-lockdown amounts, and whether there is anything that can be done other than paying the debt in the short term to satisfy the DPN. If it turns out that there are non-lockdown amounts, then there's that decision to be made about whether appointment of an external administrator of a kind is an option. And that's something that's best done with advice from both accounting and legal advisors. One option that has been engaged quite a lot with respect to DPNs is the small business restructure, which came in at a similar time to the changes to the DPN laws. And it wasn't used a great deal during the COVID years, but it's become very common with respect to these kinds of matters. It relates to businesses where the company's debts total less than $1 million. There are certain requirements, such as lodgements being up to date, employee entitlements being up to date. So it may well be that for some companies, they're just not eligible. That's something that you need to get to the bottom of, because it's far less onerous than the other options. So it leaves the directors in control of the company, whereas administration and liquidation do not. It's often far less expensive a process. So if there are significant non-lockdown amounts and a company is eligible for an SBR, that might allow them, subject to what their other creditors might be, to put a proposal forward that sees them paying a greatly reduced amount and removing their personal liability and then being able to continue the business. If it's determined, for example, that the business is just not viable, but there are still those large non-lockdown amounts which might be able to be avoided as a personal liability, then liquidation might be the option, because if there's no desire to continue trading on, then there's no reason to keep in control of the company. But there are a lot of consequences of appointing any external administrator, no matter which kind it is. And some of them are obvious, but some of them are often not obvious. It could, for example, trigger a default on a banking facility. It might be that you have personal liabilities apart from the DPN that you might still have. So getting professional advice, firstly from an accountant, also from an insolvency practitioner, and also from your legal advisors is critical and may well influence the decision you make and result in a dramatically better outcome than either burying your head in the sand or trying to do it yourself.
And I might just add that in respect to that SBR process, the small business restructuring process, you are frozen out of doing that if you've previously used the SBR process within the last 7 years. That can be significant if there's any instance of related companies, because your lawyers may be able to make an argument that the companies are related, and that can sidestep that freeze out of that 7 year period.
Yeah, that's a good point. Well, it sounds like the SBR is a good option, but there are those conditions on it. Sort of getting the sense from what you said, Seamus, that it's you got to act fast, and it's getting those right people, the trio, the holy trinity of accountant, lawyer, and insolvency practitioner, and getting those pieces of advice that you need from each of those, and then doing that all within a very short time frame.
Yeah, and that's all. Everything we've discussed has been sort of presupposing that the DPN is accurate. There's also the possibility that either it's not, or that you have defences. But if you've got defences, that's something that forms part of the decision-making matrix, and you need to know about it. Some people, I think, make the assumption that because illness can be a defence, that because they were ill for a small part of the period, that they might well have a defence to a large part of the claim, but it doesn't work out to be that way. If they weren't incapacitated to a sufficient degree, or if it wasn't for very long. So these are the sort of things that you need to consider before you go down the path of, say, appointing an external administrator. Getting that key professional advice at the earliest possible opportunity is likely to result in a dramatically better outcome than doing nothing.
Picking up on that point about illness, we have had people speaking to us and talking about how they were ill during the period of the DPN, and in most instances, it's not of a sufficient severity to trigger that defence. The case law has been fairly robust in specifying what illness would trigger that defence, and it's an illness that's debilitating enough to prevent you from running the company for the duration of that tax liability. So there have been cases of people who were regularly hospitalised, and the courts found that they couldn't rely on that defence.
Wow, that's a strict test, and as we've discussed, these DPNs are so severe. Just final question for both of you: if I'm a director, I've got one of these notices, or I'm an accountant, and I've got a client coming to me about one of these DPNs, how would I engage a lawyer to assist in that process?
Well, first things first, obviously you need to identify your lawyer and get in touch with them. I think as soon as they get the DPN, that's the critical thing, so that they can see it. And then I think arming them with the factual background, the books and records of the company that are relevant for that period of time, all of that sort of information up front dramatically drives down the amount of time required by the lawyer to get across it and give proper advice. Yeah. They may well ask for further information, but that at least gets them into it. And it might well be that off the back of that, there are some creative solutions that come about. One thing that we haven't touched on yet is if all other options are hopeless, There are personal insolvency options as well for directors who undoubtedly owe an amount and don't have sufficient assets to pay it. We've seen that personal insolvency agreements, for example, have often been accepted by the ATO where there's an offer to pay an amount that would be better than the ATO would receive in a bankruptcy scenario. So that may be an option of last resort. But again, it's a matter of getting that advice up front.
Yeah, I think that's the point, essentially. Be proactive. And if you haven't been proactive, the best time to start is now and, assess what options are available, speak to the right people and hopefully get the best outcome.
Yeah, that's right.
Thank you both for being part of this episode. And if any listeners have any questions, I'm sure you'll be happy to have them reach out to you directly via our website.
Absolutely, we would.
Thanks, Andrew. Pleasure.
Thanks, Andrew.